Hello, everyone, and welcome to the IHIMA podcast. I'm Elizabeth Keith, your host for today, and one of the co-chairs for IHIMA's Legislative Committee. We also have Pam Holliday, who also serves as a co-chair for the Legislative Committee. We have a very special episode lined up as a teaser for our upcoming fall conference. Today, we're diving into the HIPAA final rule on reproductive rights. That's a topic that's both very timely and crucial. Before we dive into our discussion, let me introduce our guest. Charise Frazier is an attorney at the Indianapolis office of Hall Render. With a focus on general health law, Charise also works with a variety of healthcare entities on matters ranging from clinical services and patient care to data management and compliance counsel. She brings over 18 years of experience in advising clients on state and federal privacy and security laws. Welcome, Charise.
Thank you, Elizabeth. It's good to be here.
We really appreciate your time, so we're going to jump right in. Our first question is about the thought process behind this law. Can you shed some light on what may have motivated the creation of the HIPAA final rule on reproductive rights?
Certainly. Well, I think as most people know, the legal landscape around reproductive health care shifted significantly after the Dobbs v. Jackson case in 2022 when it overturned Roe versus Wade. So this final rule is really in direct response to that. It's responding to President Biden's executive order regarding safeguarding access to reproductive health care following the Dobbs case. And as you guys know, the Dobbs case removed the federal constitutional protections for abortion and returned the regulations of abortion back to the states. Well, President Biden issued an executive order and directed the U.S. Department of Health and Human Services to take additional action under HIPAA to ensure that sensitive information related to reproductive health care was better protected. It was intended to be able to help strengthen that patient-provider confidentiality relationship, and also ensure that people continue to have access to high-quality care. So this final rule includes some additional privacy protection when protected health information is sought for the purpose of identifying, investigating, suing, or prosecuting someone for either seeking, obtaining, providing, or facilitating lawful reproductive health care. And so, yes, so the thought behind this is that additional protection was needed in light of the Dobbs case. OCR has stated that this additional support for privacy, it's not intended in any way to obstruct lawful investigations or to prevent states from imposing liability on unlawful reproductive healthcare provision, but it is intended to add that additional level of protection. They recognize that as a result of this new rule, that it may create some difficulties for law enforcement or certain officials who are seeking information. But after weighing kind of the risk and the benefits, OCR determined that there was, the countervailing privacy benefits justified putting this rule in place.
Great, thank you. That makes a lot of sense. Protecting such sensitive information is really essential. Moving on to our next question, how does this rule impact oversight activities? Specifically, does it include state mandated reporting or agencies?
That's interesting because there was some changes to the definition of public health. So as you guys know, generally HIPAA does not preempt state laws that provide for certain public health reporting, such as the required reporting of a disease or injury, a birth or death. But this final rule, it actually modifies the definition of public health, wanting to make sure that there is a clear distinction between what are public health investigations and what may be considered criminal investigations for the purpose of applying the preemption rule. And so what is happening here is, whether the terms that are used are public health surveillance or public health investigation or public health intervention, this final rule wanted to clarify with the definition of public health that it is focused on population health activities to really prevent disease and promote the health of populations, activities including identifying or monitoring, preventing or mitigating ongoing or protective threats to the health and safety of a population, right? And so state laws requiring the use or disclosure of PHI for the purpose of investigating or imposing liability on a person for the mere act of seeking or obtaining, providing or facilitating reproductive health care, or even identifying a person for such activities will be subject to the preemption laws, right? And so what happens here is that as we look to think about what oversight activities can happen, what OCR is saying, hey, we don't want lawmakers or others to hide behind public health activity to seek out information that they may not otherwise have a right of access to. And so the two things are happening here. The definition has been modified so that it can make it very clear what those health oversight activities might look like, but also have stated that, the preemption rule is still in play. The minimum necessary rule is still in play. None of those things change when it comes to trying to determine what's appropriate and what exception under HIPAA would you use for the purpose of obtaining information that might be related to reproductive health.
Thank you. Yeah, it's really good to know that they put that consideration in and they're trying to create that balance between privacy and the necessary oversight. Now, kind of shifting a little bit, what happens if a form related to this rule is not signed or if the requester refuses to sign it?
So in order to kind of implement the general prohibition, and the prohibition essentially is that this final rule prohibits the use or disclosure of protected health information related to lawful reproductive health care. Right. So there's a prohibition on use and disclosure of protected health information related to lawful reproductive health care. And in order to implement the prohibition, before using or disclosing PHI potentially related to reproductive health care, a covered entity under HIPAA or a business associate must first obtain a signed attestation. And this is new. This is new. It's under this final rule, and they have to get the signed attestation from the person or the entity who's requesting the use or disclosure when that request relates to either health oversight activities, which we just talked about, judicial and administrative proceedings, law enforcement purposes, or disclosures related to the coroners or medical examiner. So if there's a request for PHI that is potentially related to reproductive health, and that that phrase potentially related is important. It's important because the definition of reproductive health is also very broad. So under the final rule, reproductive health is really considered just the subset of the definition of healthcare under HIPAA. It means healthcare that affects the health of an individual in all matters relating to the reproductive health system and to its functions and processes. And it was intended to be very broad, so that you could provide that greater protection to individuals. And so what happens is that if someone's requesting potentially related reproductive health information, it falls into one of those 4 categories of health oversight, judicial and administrative proceedings, law enforcement purposes, or disclosures to coroners or medical examiner. Before a covered entity or a business associate can release that information, they must have the attestation. OCR has issued what they consider to be a model one, and they've provided some instructions on the requirements of it. So very similar to authorizations under HIPAA, this is a requirement. And so if the requester falls into one of the categories and they do not sign an attestation, then the covered entity or the business associate is not permitted to share that information. So it does serve as a stopping point. Like if you request this information, you have to have that attestation signed in order for that information to be released. If it's not signed, then the information cannot be released. And while covered entities, they're not necessarily required to investigate the validity of an attestation. They are generally permitted to rely on it if it's reasonable, that the request is not for one of those prohibited purposes. So this rule is also saying that if you have a reason to believe that the request is being made for a prohibited purpose, then as a covered entity or business associate, you're also prohibited from sharing that information. So it's not an option for the requester to not sign it if they want the information.
All right, thank you for clarifying that. It seems like it's going to be very important for a lot of different key players to understand these nuances, providers, healthcare professionals, patients, and law enforcement as such. Before we wrap up, is there anything else you'd like to add about the final rule on reproductive rights or about the upcoming presentation for our fall conference that we mentioned earlier?
The only thing that I would add is that, as I mentioned earlier, the Dobbs case really has significantly changed the landscape. So not only are you seeing this federal rule come out, but there are state laws that also have expanded protections and are implementing significant restrictions when it comes to reproductive health care, gender affirming care, all of those services. And so we'll be talking more about not only this federal rule, but also the things that are happening, right here in Indiana from a state law perspective, and then also what may be happening across the country as well.
Great. Thank you so much, Charise, for sharing your insights with us today. We're looking forward to your full presentation at the fall conference. And to our listeners, thank you for tuning in. Don't forget to register for the fall conference. It's on Friday, November 8th, to hear more from Charise and other health information experts. Until then, stay informed, and we'll talk to you next time.